Good afternoon. May I welcome everyone to the 22nd meeting in 2020 of the Delegated Powers and Law Reform Committee. We have apologies today from three of our members, Gordon Lyndhurst, Mary Fee and Gil Patterson. May I welcome Tom Arthur to the committee as a substitute. The first item of business is to propose that the committee takes items 4, 5 and 6 in private, as these involve consideration of future reports. These will be published when agreed. Does the committee agree to take items 4, 5 and 6 in private? Okay. Under agenda item 2, we are considering instruments subject to the made affirmative procedure. No points have been raised on the Health Protection Coronavirus Restrictions Scotland Amendment No. 4 Regulations 2020, SSI 2020-182, or the Health Protection Coronavirus International Travel Scotland Amendment No. 2 Regulations 2020-184. Is the committee content with these instruments? Thank you. Under agenda item 3, we are considering instruments subject to negative procedure. Prison and Young Offenders Institutions Coronavirus Scotland Amendment Rules 2020, SSI 2020-175. This instrument makes amendments to the Prison and Young Offenders Institutions Scotland Rules 2011 to make provision about the possession and use of authorised personal communications devices and virtual visits in prisons. The instrument was laid before the Parliament on 15 June 2020 and came into force on the same day. This does not respect the requirement that at least 28 days should elapse between the laying of an instrument which is subject to the negative procedure and the coming into force of the instrument. The committee is therefore required under standing orders to draw the instrument to the attention of the Parliament under reporting ground J for failing to comply with the requirements of section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010. Does the committee therefore wish to draw the instrument to the attention of the Parliament under reporting ground J? Okay, thank you. The committee also considers the reasons for the breach of the 28-day rule, which in this case are set out in a letter to the presiding officer dated 15th June 2020. The letter explains that the changes made by the instrument were required to be implemented quickly in order to properly equip prison governors with the means to provide those in their care with the ability to maintain contact with their family and friends, both during the coronavirus outbreak and beyond. It states that the outbreak has necessitated a number of restrictions to the prison regime, including restrictions on visits, and that the new forms of telecommunications are therefore vital in order to safeguard the convention rights of prisoners and their families during the COVID-19 outbreak. Is the committee content with the reasons given for the failure to comply with section 28.2? Thank you. Plant Health, Official Controls and Miscellaneous Provisions, Miscellaneous Amendments, Scotland Regulations 2020, SSI 2020-176. This instrument makes various changes to plant health regulations to strengthen plant health protection, implement required EU measures and revokes the Plant Health, Official Controls and Miscellaneous Provisions, Scotland Amendment Regulations 2020, SSI 2020-152. The instrument was laid before the Parliament on 16 June and parts of the instrument come into force on 26 June and the rest coming into force on 27 June. As with the previous instrument, this does not respect the requirement that at least 28 days should elapse between the laying of an instrument which is subject to the negative procedure and the coming into force of the instrument. The committee is therefore required to draw the instrument to the attention of the Parliament for breaching the 28-day rule. Does the committee therefore wish to draw the instrument to the attention of the Parliament under reporting ground J? Thank you. The reasons for the breach of the 28-day rule in this case are set out in a letter to the presiding officer dated 16 June 2020. The letter explains that the EU Commission reviewed UK measures that were due to come into force on 27 June and decided that they were not justified. In light of that decision, SSI 2020-152 has to be revoked before it comes into force. This instrument does that, then remakes the instrument without the problematic elements. The revocation of SSI 2020-152 comes into force on 26 June to prevent it coming into force as it would have on 27 June. The remainder of the instrument comes into force on 27 June when SSI 2020-152 would have come into force if not for this instrument. Is the committee content with the reasons given for the failure to comply with section 28.2? Thank you. No points have been raised on SSI 2020-172. Is the committee content with this instrument? Thank you. I now move the meeting into private.